topic is going to be the lawsuit and liability exposures in your jobs. This course will be taught by Bill Hughes primarily. Bill's an attorney and has been at the General Counsel for the National Association of Federal Veterinarians for 40 years. NAFV is an officially recognized association of veterinary supervisors and managers dealing with a number of federal agencies, primarily APHIS and FSIS. Up until his semi-retirement 3 years ago, he provided individual representation to NAFV members in investigations to defenses to disciplinary action. Bill has been and is continuing to represent the association and to work with agency management to improve APHIS programs and matters affecting veterinary employees. And also with us, we will have Anthony Bergnetti, or Tony, who will provide additional commentary during the presentation. Tony was a partner in a Washington, D.C. law firm where he specialized in federal personnel and employment law, representing federal employees in various disciplinary cases. He also provided legal representation to small federal agencies on a multitude of federal personnel law matters. Tony is currently the president and founder of Federal Employee Defense Services, or FEDS, and he is one of several liability carriers providing professional liability coverage for federal employees. Okay, Bill, so why don't you go ahead and let's get started.
Good afternoon, everyone. I'm very glad to be with you today, even if it is by disembodied voice. I hope that I've anticipated most of your concerns, and I will address both the staff and the field folks. I understand there's an opportunity at the end for questions and answers, and both Mr. Bernetti and I will be available to do that. First, in my presentation will be a bit of an overview. Then I'm going to give some detailed information, which will be concluded by some specific recommendations. I hope you will feel free to take notes on these. Throughout my presentation, most matters can involve both the threats of lawsuits against you as an individual, as well as potential agency charges of misconduct or lowered performance appraisals. I'll address these throughout this, and also more so in my final section on recommendations. Before I do that, I want to get into a bit of the background. In the United States, our law derives in large part from the English common law, going back 1,000 years or so. Under English common law, it was considered to be treason to even criticize the sovereign, that is, the king or the queen. Lawsuits against them were unthinkable. The doctrine is the king can do no wrong. This concept is called sovereign immunity. This doctrine of sovereign immunity, that is, the government or its agents were beyond suit, passed down to us, believe it or not, until the passage of the Federal Tort Claims Act in 1946, when for the first time the U.S. government could be sued for specific enumerated acts of its agents. This was the first waiver of the doctrine of sovereign immunity, and that is the king, however in our case the government, could do wrong and could be held accountable for it. This went on for a long time, with official immunity protecting individuals who acted as agents of the government, and with the Federal Tort Claims Act making the U.S. the sole and only defendant in these specific cases. All this was to change in a series of events beginning in 1967 in Brooklyn, New York. A guy named Webster Bivens and his family were home one night when the door to their apartment came crashing down. In rushed 6 federal narcotics agents who ransacked the apartment, dragged Mr. Bivens in handcuffs out past his neighbors who had gathered because of the commotion. At the police station, he was subjected to a strip search. Then he was released. The agents had raided the wrong address. In 1971, as a result of a lawsuit that Mr. Bivens brought against the 6 federal narcotics agents, the U.S. Supreme Court held that money damages could be assessed against individual federal officials for violating someone's constitutional rights. Could I have the next slide, please? This started the main problem at issue today, that is, individual federal employees being sued for constitutional torts for their official acts. Let me define what a tort is. There are 2 basic kinds of torts: common law torts and constitutional torts. A common law tort, the most common, is a wrong committed against an individual other than contract, which is not necessarily or specifically prohibited by law, but it can be. These are such things as negligence, libel, slander, or assault and battery. On the other hand, a constitutional tort is the alleged violation through the use of governmental authority of a right guaranteed to a citizen by the Constitution. These include such things as civil rights violations, denial of free speech, press, or religion, but the type most often encountered by you folks and other federal employees concern alleged due process violations. That is, an alleged violation of the Due Process Clause of the Fifth Amendment, which in part states that no property can be taken without due process of law. But you're saying in your mind that suits are permitted only for alleged deprivation of constitutional rights. And what I do every day doesn't have much to do with constitutional rights, so I'm okay. There is virtually no fact situation that a lawyer worth his or her salt cannot frame in constitutional terms. The allegation can be for violation of a constitutional right, usually of the Due Process Clause of the Fifth Amendment, that is, being deprived of property without due process or law, due process meaning proper and fair and recognized procedures. Anytime that you're dealing in matters that involve property interests or a property right, including the ability to earn income, it can be a constitutional matter. In some general terms, these matters include those on the staff of NCIE that have difficulties trying to balance the goal of facilitating trade with health, safety, and quality issues, and the desires of shippers, receivers, and the foreign countries. Diligence is required in assessing disease conditions in the U.S. and foreign countries and developing and issuing permits and certifications and other policies. Areas of vulnerability for field folks include keeping aware of the often frequently changing requirements and conditions, performing tests, assessing isolation requirements, and being meticulously accurate on certificates. That final thing is particularly important for you folks. Sometimes it's difficult to be firm concerning rules and procedures related to animal health when faced with pressures from those either who have convenience or self-interest paramount, but you have to do it. In addition to the trauma of just being sued, we know it's very easy to file a lawsuit. It's certainly a lot more difficult to have it maintained or to win. But the bigger concern to this group is whether or not a suit can be maintained against you. Being held liable, sort of like being found guilty, is terrible. But being sued in and of itself is a problem. You can and probably would be subjected to depositions, interrogatories about your personal assets and finances, and just try to borrow money to send a child to college or to get a mortgage with a lawsuit pending against you. Since 1971, when the Bivens case first became law, the courts have gradually eroded the potential for individual liability. In a case called Bush versus Lucas, and that's not one of the presidents, the case held that a suit cannot be maintained against you as a supervisor if there are administrative remedies available to your subordinates, such as the EEO process or grievances. I know it may not seem like a benefit if someone can file a grievance or an EEO complaint against you, but it sure beats having a lawsuit filed against you. In 1982, in a case called Harlow versus Fitzgerald, which modified the Bivens decision again, a federal official was entitled to what is called objective qualified immunity in these constitutional sorts. This is a big help. Previously, the law had been subjective qualified immunity. That is, an individual would only be liable for a constitutional violation if a jury determined that he or she did not act in good faith. Now, under the Harlow decision, the judge decides before a trial begins whether or not there was a violation of clearly established constitutional guarantees, and if the individual was following clear guidelines, such as directive or regulations, or if the individual reasonably believed that the actions were proper. In these cases, they can be dismissed even before discovery, but you have to have acted with reasonable beliefs that what you were doing was proper, following established agency policies, and you have to convince the judge. Just a reminder, for other than constitutional torts, that is common law torts, there's absolute immunity. The suit against the individual will be dismissed and the government will be made the sole defendant. This is thanks to the Federal Tort Claims Act and a 1989 statute called the Westfall Statute, which overturned a 1988 interpretation of the Federal Tort Claims Act in a case called Westfall versus Irvin, which had held that there could be individual liability even for common law torts in addition to access to plaintiffs under the Federal Tort Claims Act. Could I have the next slide, please? These are my recommendations. 1, how can I guarantee that I won't be sued? The answer is, you can't be guaranteed that you won't be sued. You can increase the odds against you being sued. You can increase the odds tremendously against being held liable or shielding yourself financially if you are. You want to reduce your vulnerability both to federal lawsuits and to allegations of misconduct. First, you must realize that in this day and age, the threat of a lawsuit is the price of doing business. Do not let this deter you from doing your job. Remember, what I'm talking about also is aimed at reducing the possibility of charges of misconduct. But if you are charged with misconduct, remember that you too have good due process protections before the charges can be sustained. I want you all to think about this and to re-examine the way you do business. Recognize that there is a potential for lawsuits and for charges of misconduct, and do the following. 1, keep a business relationship with all those with whom you deal. Certainly never be hostile or rude, but on the other hand, don't be overly friendly either. Remember that you are the representative of the federal government. Also remember that the people you come into contact with look upon you that way, and that the federal workplace is not an extension of your social life. Number 2, keep good records so that you know, even years after, what happened in a controversial situation. Don't rely on your memory. 3 or 4 months after the fact, if you find out that somebody's making a charge against you, whether it's your agency or whether it's a lawsuit, you don't want to say, gee, I remember something happened, but I don't know what it is. If you're involved in a controversial situation, make a memo to yourself, but don't keep it on your government computer. Make sure that you keep it on your personal computer or a hard copy as well. Very important, follow written guidelines, statutes, regulations, and directives to the best of your ability. If you are unsure, make sure you go and check. If you are unsure, check with your supervisor or with one of the IE experts. Don't rely on just the way you've always done things in the past or what you think might be right. These things are very important. Don't sign permits or certificates unless you are sure. Be sure you can justify why you signed or why you didn't sign. In any controversial situation, hypothetically think, what will I answer if I'm asked, why did I sign this? Why did I do this? Or why didn't I sign it? Or why didn't I do this? You have to justify it or be prepared to do so each way. Number 5, beware of doing anything that you're not authorized to do. Don't exceed your authority. Certainly don't make commitments that you don't have the authority to make. Don't promise somebody that something is going to happen when you don't know for sure that it is. And be very careful about making predictions also, because people tend to rely on those. Be very conscious and aware, number 7, of unwritten policies that may conflict with written ones. Many times in situations you say that this is the way we've always done it, this is the way somebody told me to do it, this is the way somebody else does it. You can't do that. You have to be sure that you're following the existing policies. Don't be afraid to explain why you have done things, why you've made a certain decision. Do not get involved in a debate. But don't be afraid to explain things, because many times if you're acting in good faith and other people are acting in good faith, An explanation will be sufficient. Do not do this after a lawsuit is threatened, especially if you're contacted by someone you're representing, the plaintiff's attorneys or the plaintiff's attorneys. They don't want to be convinced. At that point, if there's an attorney involved, he or she does not want to be convinced. They want to pump you for information to make their case stronger. Number 9, realize that due process requires both sides to be heard. This is especially true for withdrawal of government-granted privileges, especially to those who do business with or earn money, or the taking of a property right. 10, if you have a question, contact your Office of General Counsel directly anytime there's a threat of a lawsuit against you. Do not make the mistake that many people have made in the past and rely on your coworkers or your supervisors to give you legal advice. Third, recognize that the likelihood of a lawsuit is slim and that an adverse verdict and judgment is very remote. Good faith plaintiffs usually don't want to sue you. This is because of what we lawyers call the deep pockets theory. The government certainly has more money than you might have. And a good faith plaintiff, if he or she feels that they have been wronged, are going to want to go where the money is. Do not publicize the fact if you have professional liability insurance. Don't publicize that. I hope you have it, but if you don't, but if you do have it, don't publicize it, because this will create the appearance that you have deep pockets. Bad faith plaintiffs usually don't have very good cases. Their threats and sometimes even their lawsuits are designed to harass you and intimidate you from performing your job. Number 4, fourth, very important. Shield yourself as best you can from potential financial liability. There are 2 ways that I recommend that you can do this. One is to make yourself judgment-proof. That means getting rid of all your assets, placing them in your spouse's name. Of course, in 2012, this may be more of a risk than a lawsuit, so certainly we don't recommend that. The more practical way is to purchase professional liability insurance. Make sure this insurance will cover the type of work that you do. Again, don't publicize the fact that you have it. Those of you that are veterinarians, be aware that the professional liability policy offered by the American Veterinary Medical Association is highly unlikely that will cover you in any of your work situations. It's designed for clinical practitioners and educators. There are several professional liability insurance policies available which are specifically designed for federal employees. Back in the early 1980s, NAFE was involved with helping to create one of the earlier ones, but things have evolved and we are where we are now. NAFE does not make any money on any particular policy, so I do not hesitate to recommend one in particular. This is the Fed's policy that Mr. Vernetti is going to address. NAFE compared the major policy providers and strongly recommends that every one of you purchase it. While NAFE members have a special relationship with Feds, it is available to all of you and provides protection against lawsuits and, very importantly, charges of misconduct. Mr. Tony Vernetti will be providing details following my presentation. Despite the coverage of the insurance and the quality of the attorneys used by Feds, if you are sued for an official act, the Department of Justice will most certainly provide you with representation by a U.S. attorney if you choose. I strongly recommend that if you're in that unfortunate situation, that you do utilize a U.S. attorney. They know what they're doing. They do it all the time. They have experienced supervisors and extensive case files. In order to be represented by a U.S. attorney, you must have 2 requirements. First, the act or omission alleged must be involved in the scope of your employment. Very, very important terms, and I'm sure you've heard those before. That is, it must be a result of and a part of your official duties, that is, what you're hired to do. This doesn't just mean anything that occurred during working hours. It's a part of your official job. This is the primary argument by plaintiffs who are after you personally, that what occurred was not within the scope of your employment. and that it was not an officially authorized act. Again, remember what I said about good faith plaintiffs, though, because they want to go after the federal government. Second, representing you must be in the interest of the United States. It's the policy of the United States, though, and the Department of Justice to provide representation wherever possible. This is, quote, to promote the vigorous enforcement of your duties, unquote. And this is codified in the Code of Federal Regulations. If your interests do differ from the interests of the United States in many cases, the government may pay for a private attorney if funds are available and if you do need the government to pay. Be aware also that the USDA has the authority these days to indemnify individual employees against whom a judgment was rendered. This was not always the case. Unfortunately, though, this means that if the USDA chooses, it can pay such judgment that's levied against you. This helps, but it's no guarantee, so that's why it's important to make sure that you're covered financially by insurance. In closing, do not let a fear of lawsuits interfere with you doing your job. It is more dangerous not to do your job than to let the fear of a lawsuit interfere with that. Do take the precautions I have enumerated to reduce your risk of charges of misconduct and lawsuits, and especially protect yourself with appropriate insurance. Thank you very much. That's the end of my presentation.
Well, Bill has done a really excellent job at covering the important issues, so I just really want to take a few minutes and tell you a little bit about the insurance and what it covers. It provides $1 million to $2 million to satisfy judgments. Bill was talking about the interest of the United States. If justice is on the fence as to whether they're going to answer that question in the negative and not provide you representation, we will provide what's called coverage counsel to go in there and hopefully convince the Department of Justice to provide you representation, because it's very important, as Bill has mentioned, to get the Department of Justice to represent you. If they don't, we will obviously represent you, but at the end of the day, it is very important to try to get the United States to stand up in court and stand behind its employees and say that, you know, we are representing you. So that's an important emphasis. I want to pick up where Bill just left off in how important it is to have the United States Attorney representing you in federal court. So as Bill said, it's a two-part test. You know, are you in scope of employment, which is usually yes. You're usually in the scope of your employment. It's the second part of that. Interest of the United States is to where if that's answered in the negative, you know, while you may still have all those wonderful immunity protections, may even be able to, you know, pull in with what Bill talked about as qualified immunity and things like that. If you're on your own without liability insurance, you know, it can cost you, you know, $25,000, $50,000 of your own money to go in there and defend. So that's an important aspect, you know, of the policy. And the interest of the United States test, as Bill pointed out, is more of a kind of public interest one, you know, governmental interest one. It's not necessarily designed to one specific situation. It's, you know, kind of, you know, what is the governmental interest here? The times that we have seen that answered in the negative is if you're being investigated for some sort of wrongdoing for the very same reason that you are being sued, you can see that the Department of Justice may not want to be on both sides of that. So that's the type of situation where the insurance can come in and provide the full legal defense for you. But the other important aspect of it, even if you are covered and DOJ is representing you, we may on occasion appoint coverage counsel to kind of oversee DOJ's representation of you. Not that they're not very good at what they do. They're the best in the business. Their duty of loyalty, their interest is to the United States, and we're, of course, concerned for you, so we want to make sure that they're never adverse, you know, advancing an interest that's adverse to yours. And again, that other really, the other important part of this piece here is that if DOJ is on the fence, they're going back and forth whether it's in the interest of the United States to represent you, we will appoint coverage counsel who know these lawyers in DOJ to go in there and convince them that it truly is in the interest of the United States to provide you representation. And then, obviously, the point that Bill made, regardless of who's representing you, if you are actually found liable and your department declines to indemnify you, it is your liability. It's a personal capacity lawsuit against you. You don't have absolute immunity for personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. The other part of the policy, what I call, a huge bang for your buck in the environment that we're currently in, where we're constantly investigating our employees, is it provides $200,000 in attorney's fees for any administrative matter. So this is any investigation, any congressional investigation involving you, any management-directed investigation, any Office of Inspector General investigation if you are a manager, any Office of Special Counsel investigation and the whistleblower reprisal, somebody files an EEO complaint against you, any administrative investigation whatsoever. The policy will provide you with your own lawyer, what I call cradle to grave, from the start of any investigation up until the conclusion of it. And in the unfortunate event that there's a disciplinary action taken against you, a reprimand, a suspension, demotion, God forbid a removal from federal service, the policy will provide a legal defense, will provide an attorney to defend, both at the agency level and if you have to appeal it to the Merit Systems Protection Board, it would cover that type of appeal as well. Finally, the policy provides up to $100,000 to defend against any act or omission that results in a criminal investigation. Now, I know none of you come to work, you're all dedicated civil servants. You're not coming to work to commit a criminal violation, but I'm here to tell you that there's very little you can do wrong in the federal government and not also have it technically be a violation of Title 18, which is the criminal code. So it's important to have that protection there as well. One of the most important pieces, I want to emphasize, I don't want to get a whole lot into, what types of claims are covered and things like that. We're going to be happy to answer questions. But I really want to emphasize how inexpensive it is. It's $290 annually or $390 annually for a $2 million policy. If you bought the insurance for an entire career, you never had to use it, what's that going to cost you? About $7,000? When you retire, that's not going to affect your standard of living, at all in retirement. Whereas if you had a claim and you needed to hire your own lawyer, that is going to greatly affect your standard of living when you retire. You'll pay more for 1 hour of legal service than what the annual premium costs. I should also mention, because I know we have a handful of supervisors and managers who are on the webcast today, that the agency, Congress has authorized, mandated legislation that requires agencies to pay up to 1/2 of the cost of the liability insurance, and they generally cap that at $150. So for those of you who are managers and supervisors, you're looking at the insurance really costing you annually about $145. I like to say that's not even one of my wife's shoes. Not even a pair, I mean, it's only one. We also have payroll deduction available. I should also mean, even though you're not a manager or supervisor, it does not mean that you don't need the insurance. It's just that Congress, in all their infinite wisdom, has only identified that specific group as well as law enforcement officers. But there are plenty of other groups of federal employees like yourselves who are out there making decisions that have real-world impact on finances for companies, and you're making real-world decisions that affect public health. So you don't need me to tell you about those potential vulnerabilities. We have payroll deduction available. It works out, I think, to be about $12 a pay period. If you are an NAFV member, National Association of Federal Veterinarians, we offer a small discount to those members as well. You can call the office and see about how you get that discount. You can enroll a variety of different ways. The easiest way is to just go online at the website. It takes less than 5 minutes. We can send you a paper enrollment form, or you can give us a call and we'll get you enrolled over the phone. The most important point is this last point, is I can't tell you how many calls I take every given week from folks who already have something going on, who say they've never heard about the insurance. Just like any other insurance, you need to have it in place before the allegation occurs. You can't get in a car accident on Monday and think you're going to buy your car insurance on Wednesday and have you cover it. So it's very important that you get the coverage in place. That's all I had. So I guess we'll open it up for questions, which I think Kathy is going to facilitate those questions for us.
Correct. I know that you're all familiar with the GoToWebinar, but if you are not, there's a control panel in your right-hand corner. If you do not see that, it's the orange-red arrow. If you click on that, it'll expand your control panel. Then if you go down to the questions section, you can click on the plus sign, and that'll expand your question section so that you can type in your questions. And Tony and Bill are also accepting live questions. If you raise your hand, we can unmute you at that time. Thank you.
And while we're waiting
Tony,
for questions, as usual, we'll record this and post it for those that missed the live broadcast. Go ahead, Kathy.
Thank you. Your first question, Tony, is does the coverage automatically renew from year to year?
Yeah, the coverage does automatically renew year to year. Depends how you pay. If you pay in full by credit card or check, you're going to need to obviously send in your payment each year, and it renews. It's not, if the question is about deductibles and using your insurance, like homeowners, if it goes up and things like that, the insurance doesn't apply that way. It tends to, although we just had a small price increase, it tends to stay the same price across the board for everybody. Simply because you file a claim, it doesn't change your eligibility for a renewal next year. We realize there are folks in certain positions that are just more vulnerable. If you're in payroll deduction, we'll simply send you a notice annually and send you your new certificate of insurance and give you an option if you wanted to discontinue that and pay a different way. So it does renew annually, but you need to make payment if you're not in payroll deduction.
Your next question is a two-part question. Did you say that the AVMA Fed insurance won't cover us? If not, why are you offering it to us?
No, I think that's Bill was mentioning how what's the acronym, Bill? The AV.
I think this question is directed toward me. I said that the American Veterinary Medical Association professional liability insurance will not cover your federal duties. It is designed to cover those in clinical practice, those treating animals on behalf of a client. It does not cover the type of work that federal people do. Of course, only veterinarians are eligible for the AVMA policy, but our association, being an affiliate of the AVMA, thought that this is what we would offer back in the 80s when individual lawsuits first became a real threat that we knew about. And we determined that the AVMA policy does not offer the type of coverage directed toward the type of work that federal employees do.
So so just to be clear, this type of insurance that we're talking about, the Fed's professional liability insurance, is specifically designed for the kind of work that you do as a federal employee. It's specifically tailored to that kind of work that you do as a federal employee. So it covers you for every act, error, omission that you do as part of your federal responsibilities, whether it's your veterinarian work, whether it's your supervisory responsibility or some other collateral duty. Any allegation that comes out of your federal responsibilities, you are going to be covered by our insurance.
Thank you, Tony. Another question is, what recourse do I have if my supervisor wants me to endorse certificates that contain information that I believe is inaccurate? My supervisor says that as long as I accredit the practitioner signed the cert, I will no longer be liable when I endorse it. Is this correct?
Bill, I would defer to you on the specifics, but generally speaking, you have to follow orders if they are lawful. If you feel the order is unlawful, you can request, to have a legal opinion or, defer to certification on up. But I would defer that question to Bill, who's got many years of hands-on experience with those issues.
I'm not sure I quite understand the situation, but I think I do. And it's a situation where your supervisor tells you to do something where you think the facts on the certificate are contrary. The facts as stated are really not accurate. Your supervisor cannot absolve you from responsibility, and I think in many cases the supervisor would have a short memory if he or she told you to do something that later turned out to cause you to be liable. If you put your name on that, you become responsible for it to the extent that statements are made in the certificate. If it says that you're relying on the certifications of an accredited veterinarian, whether it be for the health of the animals or the facilities in which they're held in isolation, then you're okay. But I don't believe that they do say that. I think that you're on dangerous ground if you put something down that you are not comfortable with. If you want to protect yourself, I would suggest that you politely question the supervisor, ask for justification for that. If you disagree with that, I would suggest writing what I call a confirming memo and write to the supervisor and say, dear so-and-so, this is what I've understood you to say on such and such a date, and then state what your understanding is, and say, I will follow your instruction to do this. If my interpretation of your instruction is not correct, could you please notify me as soon as possible? Thank you very much. And that way you'll have a record that you're operating under specific instructions of your supervisor and his or her interpretation of what the rules and procedures are.
Thank you, Bill. Another question is, can AHTs purchase this insurance, or is it just for veterinarians?
As I mentioned, NAFE members have some special relationship with feds, but it is open to all federal employees. I believe, Tony, correct me if I'm wrong, but you have to be a permanent full-time.
Full-time or part-time federal employee.
Okay.
So, anybody, who's federally employed, generally in any capacity, is eligible for the insurance.
Another question is, to your knowledge, have there been any lawsuits against federal veterinarians that endorse export health certificates for animal products going overseas and getting stuck?
I don't know of any. I do not know of any.
Another question.
Nor do I. I mean, the most recent lawsuit, I don't know, Bill, if you want to comment on, was and it wasn't import-export, but it did involve federal veterinarians out in California. There was an issue where there was liability.
That was in the Food Safety and Inspection Service, if I'm not mistaken.
FSIS, that's correct.
But the question is a good question, because it's not so much whether there's a history of it, it's whether there's a potential of it.
Yeah, I mean, to be fair, make no mistake about it. You know, and I always like to be fair on this issue. You know, you being on your own without DOJ representation is rare. I mean, it's 5%, you know, 6% of the cases maybe, with actual liability to you personally being even rarer. But if there's any remote possibility that it could happen, you know, that's a risk that it can happen to you, and you can insure that away at a relatively low cost, which you can, when the potential to do financial damage to you is so high, even though the probability of it happening is low. You know, most financial experts, all financial experts, will tell you that you need to insure that risk away, and that's what the insurance is all about.
May I add something there too, particularly in regard to charges of misconduct or allegations of misconduct on the administrative level. I have done this for all of my career up until 3 years ago when I retired, and I think that's about the same time that the Fed started up. Is that correct?
Yep. Yep.
People would call me and say, "I never thought this would happen to me. I've been doing my job for X number of years, and I never thought that I would be on the receiving end of misconduct. I don't think I did anything wrong." And they may be up for some very serious charge and end up having to fight for their jobs or for a suspension or whatever, and feds will cover this. And so the same thing's true with lawsuits. Even though there's a very, very remote likelihood of a lawsuit against you and certainly of a judgment being executed against you, it does exist. And people that have been in the receiving end of it say, well, gee, I never thought it would happen to me. And that's especially true for allegations of misconduct, and you can shield yourself.
Right, and that's where I say that's, you know, your big bang for your buck. I mean, the odds are more that you are going to, you know, have an administrative claim against you, some allegation of wrongdoing, whether it's from a supervisor, you know, other stakeholder, colleague, member of the public. As Bill said, it's just the cost of doing business these days. That's why I call it your real bang for your buck. I mean, I could tell you, you know, over the years 2007, you know, we get an administrative claim from a federal veterinarian about once a month. You know, it's a lot more common than you think, and it's unfortunately, I think that the hurdle that veterinarians and other federal employees have to get over is you almost have to view yourself as doing something wrong. That's really no longer the case. You know, anybody can make allegations of wrongdoing, and, you know, just in today's climate, you know, the agency is going to feel that it needs to investigate and look into all of these allegations. And when you have the weight of the government over you, an investigative body that puts a magnifying glass, a microscope over the kind of work you do day to day, every day, none of us are perfect. Okay, none of us are going to be perfect. And when you are the subject of one of these investigations, it's a lot more comforting to know that you're going to have your own legal counsel to assist you with the process, you know, from the start to the finish.
And if I may add one more thing on that, usually when allegations of misconduct are brought against an individual at whatever level, it's not by your chain of command. It's usually, or almost always, by human resources or employee relations who really don't understand what it is that you do.
Yep.
Your supervisors may even support you and say, well, gee, this seems okay to me. If something goes wrong, though, and especially in a situation where there is bad publicity or an international incident, too often somebody looks for a scapegoat, and too often that's the person whose name's on the certificate. Although we've never had any real cases with that in APHIS, or you know, people who have done something or not done something, the initial person is usually the one that somebody goes after.
Right. No, I mean, I can't tell you, in my former life practicing law at the law firm, how many times, I had to take, $25,000, $40,000, $50,000, $75,000, $100,000 of somebody's hard-earned money to defend them in an administrative matter that they just would have spent the $145 or $290 a year, they would have been fully covered. I used to say I couldn't afford me. So, I mean, you have this insurance available to you. You should give it strong consideration.
Another question is, has there been any lawsuits involving import-export vets endorsing certificates for live animals when they get stuck?
I don't know of any. There have been threats.
Yeah, I mean,
I don't know of any that have culminated in a lawsuit.
Yeah, I mean, for attorney-client privilege reasons, I can't get into specifics, but I mean, we've seen administrative activity regarding that or stuff related to that, but I don't know to have an example of an actual civil lawsuit.
I too have seen administrative actions in APHIS and in FSIS in regard to the signing of export certificates and other certifications. So the potential is very real for much more so, of course, as with everything else, for an administrative action and charges of misconduct than an actual lawsuit.
Are there daily logs of assistance, especially for those cases where an email response is not an option?
Is that addressed to me? I believe it is.
Yeah, I'm not sure I understand the question.
Yeah, I don't understand it either.
Is that as far as how to get legal advice, or is that a specific question?
What was the question in regard to my recommendation for a confirming memo to write to the supervisor to say, this is what I understood you to say, and this is what I intend to do, and is that correct? If not, notify me. That doesn't have to be done by email. It can certainly be done by fax. It can be done by letter if it can get there quickly enough. Just so you have some documentation that you are indeed following an instruction. And quite honestly, that applies also to advice from one of the agency IE experts, whether it be on staff or from one of the area offices. And if you are one of those persons, we know that you're very conscientious about making sure that the rules and regulations are followed properly, but make sure that you recognize that you're in a support capacity, and people who are out there on their own rely on you. And so don't be afraid to, if you believe something, to put it in writing. And if you don't, then you have to question the way you're doing business.
We haven't answered that question exactly. Would it be okay if I unmuted the person who asked that question?
Sure.
Hello?
Yes, can you hear me?
Yes.
Okay. The question that was posed was specifically for those cases where the supervisor or manager has a forgetful memory. So prior to, if you had kept a log, say in a logbook of daily activities or daily instructions, how is this logbook going to protect you in the event something happens? And you've had, every day there is an entry whether nothing's occurred or whether, like you said, you could have some issues with certificates that were endorsed that we know are not endorsable, but we've been given instructions. It's my experience that a few supervisors will not respond to those emails. So how do we protect ourselves in that situation?
Let me provide an initial answer, then Tony, I'm sure that you'll have more. I strongly advise you to keep good records. Certainly a letter of confirmation, as I described, is a good way to do it. Certainly not as good as if the supervisor or the expert gives you instructions in writing. But if you have a logbook, a contemporaneous logbook, that will become a business record. And it will help if there's a dispute as to the veracity of you versus somebody else. It won't be absolute, but it will help.
Okay, thank you.
Yeah, I mean, the other part of that is, you have to, and you got to sometimes be practical about what you're trying to do. I mean, you're looking, and apply some common sense. I mean, you're going to be looking, to protect yourself down the road, and this is going to be a piece of evidence, and how is it going to be corroborated? Frankly, I think the email to the supervisor saying, this is what you told me to do, so I did this, send that, that's just as good as a business record, as anything. Logbooks are great. You want to make sure it's date stamped. If you can get a witness to initial it, different things like that would help you corroborate it at a later date. That's what's going to be important. But you don't want to go so far over where the manager or supervisor feels like you're rubbing their face in it. It's just practically speaking, you may not want to bring on that sort of adversarial nature to it. But there are all kinds of ways that you can document, your logbook, whatever record you are creating, for the official record. Having a witness, sign it is, can be just as good as well.
Supervisors are not required to put every instruction in writing.
That's correct.
It's been determined that it would be unwieldy for a supervisor to provide every instruction in writing. What I addressed in my talk was primarily for controversial situations, or situations where you feel the supervisor or the agency expert is not correct. You don't want to do this for everything,
right.
But you want to make sure that if there is a controversial thing, or if you're being asked to do something that you don't believe is correct, but maybe not quite illegal, maybe just a misinterpretation, then you want to do whatever you can to document this, whether it's by a confirming memo or, at the very least, your own contemporaneous notes.
And I'd be remiss if I didn't mention this, because I've seen so much of this lately. Don't record your supervisors. With all the new iPhones, iPads, things like that, it's becoming a lot easier to press one button and you can record people. It violates most agency policies to surreptitiously, secretly record supervisors or other employees. And in some jurisdictions, like Maryland, for example, which is a two-party consent state, it actually violates criminal law. I've seen an increase in people doing that, and I've seen supervisors doing it to subordinates as well. It's just as improper. So,
under USDA regulations, if there's a recording other than by a law enforcement group, such as OIG or FBI or local police, all parties to the conversation, whether it's telephonic, computer, or in person, all parties must consent in advance to the recording. State laws vary. Federal law, it may be different, but USDA regulations are such that you cannot do it.
All right.
Thank you. Another question is, the regional office wants us to sign export certificates that do not contain complete information. They say write a letter of waiver of responsibility and have the exporter sign it. The agency won't issue an official form regarding waiver, so I don't think this is unofficial. This is an unofficial waiver. Protects me in any way. Am I correct?
I don't know. I think that in a situation like that, you would be well advised to write to the regional office and ask for clarification as to what the policy is and justification for what it is that you're being asked to do. And do so in a polite and tactful way.
Right.
Introducing it by saying, I always try to do what I'm instructed to do and to cooperate. but I don't understand what's going on here. Could you please advise me further and provide further information so that I know that what I'm doing is correct?
Thank you. Next question. You suggested that we are conscious and aware of unwritten policies that are contrary to written policy. Other than being aware, what else should we do?
Not follow them. If there's a policy in a particular location where you are that this is the way we've always done it, and yet that's not supported by directive, instruction, or regulation or statute, don't do it. And if you feel that you're correct, make sure you get clarification in writing.
And just from a disciplinary perspective, you know, particularly the past practices like that, and I can give you lots of examples, but the defense of everybody's doing it is going to get you nowhere if it becomes a subject of an administrative investigation.
I have had high-level agency officials who have told individuals who say, this is the way we've always done it, this is what everybody does. Their answer is, tell us who's been doing that, and we're going to go after them too.
Next question. Are Tony and Bill familiar with ship at your own risk documents? If such a document is signed by an exporter who is knowingly shipping a product animal without meeting the country's requirements, does this remove liability from the federal vet who signed the certificate? Is a ship at your own risk document regarded as a sound legal document?
I don't know. Again, if you're confused about it, I would ask for clarification from wherever that originated, so that you have some documentation that you're doing what you've been instructed to do.
I mean, your responsibilities are still going to be, you know, your responsibilities. So whatever decisions you make with that ship at your own risk type situation, I mean, it's still going to apply. Now, as far as real world, you know, liability of what that actually means, you know, the question really is does it absolve the United States, you know, and you know, of any liability at that point? And I don't know the answer to that.
Tony, we are done with our questions.
Okay. I'd like to thank everybody for attending. Dr. Drodar, I appreciate the opportunity to provide this information to your group. Bill, thanks for a great presentation.
Well, I thank you all very much for the opportunity to participate. I hope we did some good and at least created some awareness. Hope you enjoy the rest of the day. Thank you very much.
Thank you all for attending, and as usual, I will get the recording of this and post it on our SharePoint sites for those that were unable to attend today. And I will also request from Tony, would you please just email me the PowerPoint separately so I can post that separately. And if there are any questions that you would like to present to these gentlemen at a later date, just send them to me and I'll send them on. And thank you all very much. In October, we'll have another discussion, and it'll be about statistics of the products that USDA exports. And so look for that one. And if you have any questions or problems, just send me an email. Thank you very much.
Tony, thank you very much.
Thanks. Thanks, Bill.